Hello viewers. When a rift happens in a political party, how do we determine which faction represents the real party? This question assumes relevance in the context of the ongoing political developments in the state of Maharashtra. So today we have with us Mr. PDT Achary, who is the former Secretary General of the Lok Sabha, to discuss the law and procedure on this topic. 2 weeks back, we had another interview with Mr. Achary, where we had discussed issues relating to disqualification proceedings and anti-defection laws. So this is a kind of a sequel to that interview. So now over to you, sir. Welcome, sir. Welcome to the...
Thank you.
So, sir, in the Maharashtra context, a very curious development has happened. So the so-called rebel group led by the present Chief Minister, Mr. Eknath Shinde, he claims to have the support of majority of the MLAs. So out of the 55 Shiv Sena MLAs, at least 39 MLAs are with Mr. Eknath Shinde. On the other hand, officially, on paper, Mr. Achary, he continues to be the president of the party. So in this context, how do we determine who can claim to be the real Shiv Sena? What is the law and what is the process for such a determination?
See, when a party splits, normally the split occurs both in the organizational wing and also in the legislative wing. And that has been the pattern. We have seen this happening in most of the parties which have split at different times. And therefore, when they approach the election commission, there will be two factions of the party before the election commission. I mean, each faction will contain the organizational part of it and also the legislative part of it. That is how the election commission, or that is when the election commission decides which faction actually is the party. So that is the question which election commission will have to decide, which faction is the party. But in the Shiv Sena case, there is a difference. It is different from that pattern. Here on one side, you have the legislative wing of the party. And on the other side, you have the organizational wing plus a few MLAs. But majority of the MLAs are with Shinde, who is heading the legislative wing of that party. But under the law, the legislative wing of the party is a part of the original party, political party. Because that is the party which is registered as an association of individuals calling itself a party and registered with the election commission as per section 29A of the Representation of People Act, which is headed by Mr. Achary. Now, how can the election commission decide this? Because on the one side, you have the legislative party, majority of the members. On the other side, you have some of the MLAs plus the organizational wing of the party. Because that organizational wing has not split so far. I mean, apparently, what will happen in future, nobody can say. But at the moment, that party remains intact. Organizational wing of the party remains intact. So that is, so we should presume that it is under the control of Mr. Achary. So what is left with Eknath Shinde is only the legislative wing of the party. Now, how can election commission deal with the legislative wing of the party? That is a question which needs to be gone into. Because when we have seen in the case of the Congress party, there was a split down the middle in the party organization. They met separately. Some delegates of the AICC met at one place, and some other delegates of the AICC met at some other place, and both factions passed resolutions expelling each other and all that. That process, that essentially that continues in every party whenever the party faces a split. But it has not happened in this case. Now, a legislative wing is not registered as a party at all. So it has no legal existence as such. It consists of members of the assembly. And that group is called the legislative party. But it is not a party in the sense in which it is used in the law. So on the one hand, you have a party which is not recognized by the law. And on the other, you have a party which is recognized by the law. Now, who will the Election Commission choose as the true party? That is a ticklish question which the Election Commission has to decide. But then when there is a split in a party, the Election Commission has its own method of finding out, and the law also requires the Election Commission to collect all the facts and then hear people, not only the party, the faction leaders, but other people also who are interested in it. And after getting all these facts and the statements from all the interested people, the Election Commission will decide. And we have seen how the Election Commission has decided this issue in many cases. And the Supreme Court has okayed, endorsed those decisions of the Election Commission. It means they go by the majority test. So that is the test which has been approved by the Supreme Court, the majority test. But majority test does not mean that you merely count the number of MLAs or MPs who are with you. After all, party organization is much bigger than that. It represents the people outside and the people who have elected them. So they are the supporters of the party, and they are the real party. Naturally, you have to see how many of them are with one faction and how many of them are with another faction. So that needs to be gone into by the Election Commission. Only after that they can do that. But I think it is a time-consuming affair. It will take quite some time before the Election Commission is able to take a decision. And then again, of course, it can be challenged in the court. And finally, it will be settled only by the court if it comes to that.
So, sir, you are essentially saying that the mere majority within the assembly, that is not the sole determining factor for determining which faction can claim to be the real political party. The entire organization structure has to be taken into account. And the Election Commission is essentially determining to which group the registered party symbol that should be allotted. Right. So, it is under that process that the election rule, election symbols, reservation and allocation order. The Election Commission is exercising jurisdiction under this order. So, but here, what again complicates the situation is that now the newly elected speaker has recognized the faction, the Shinde group, as the Shiv Sena legislative party, and the other faction. So, at least in the House before the speaker, the Shiv Sena faction of Shinde group, that is the official faction, and the other group has become the rebel group. And both the parties have initiated disqualification proceedings against each other. Both the parties have elected their own whips. And so allegations and counter allegations have arisen that you have violated my whip. The other party is saying that you have violated my whip. And parallel disqualification proceedings are here. So in this context, how do the Election Commission determine? So when already the speaker has recognized one faction as the official faction.
The speaker has no statutory authority to determine this issue. Speaker takes a decision to recognize a particular group or a group only for the sake of convenience of functioning in the House. That is the only criteria, that is the only basis on which the speaker takes that decision. Speaker has no statutory authority to decide which faction is the party. That has to be decided by the Election Commission. So here what is happening is Speaker, of course, they have filed petitions with the Speaker. Speaker has to look into these petitions. Both sides, both factions have filed petitions. But in such a situation, in my view, Speaker has to go strictly by the 10th schedule. Now, 10th schedule says one thing very clearly, and that, in my opinion, will clinch the issue. That is explanation to paragraph 2. It says that it is that party which has set them up as candidates is the party to which they belong. So that means all these members, all the 55 members of Shiv Sena were set up as candidates by the Shiv Sena, which is headed by Uddhav Thackeray. And therefore, all of them belong to Shiv Sena headed by Uddhav Thackeray, unless these members merge with another party. Their party label changes only when they merge with another party. Otherwise, they shall be deemed to belong to the party which set them up as a candidate in the election. So that makes it very clear. Therefore, Speaker cannot run away from this legal obligation or this legal requirement. He has to decide things in accordance with the law. That is the thing. Now, anti-defection law is the constitutional law. So it overrides the other laws, I mean, the statute laws, particularly the subordinate legislations like election symbol order and all that. Those are not very relevant for deciding an issue relating to the anti-defection law under 10th schedule. Therefore, Speaker has to stick to this. And then Speaker will come to the conclusion that these members actually belong to the Shiv Sena, which is led by Uddhav Thackeray, because Mr. Shinde is not the president of that party. He has not elected himself as the president. He is the leader of that legislative party, legislative wing of Shiv Sena. He may be the chief minister, but that does not change his status as a member of the Shiv Sena under the 10th schedule.
So basically, just to recap what you have said for the easy understanding of our viewers, you're basically saying that the explanation to paragraph 2 of the 10th schedule, that will play a very crucial role in this issue. And as per that explanation, a person will be deemed to be belonging to a political party by which he was set up as a candidate. So here, since Shinde and other MLAs were set up as candidates by the Shiv Sena group headed by Uddhav Thackeray, so they will be deemed to belong to that section, that group, unless there is a merger with another political party as per paragraph 3.
Yeah.
So paragraph 4. So this provision, that is explanation A to paragraph 2 of 10th schedule, that plays a very crucial factor.
Yeah.
And this has to be decided by the Speaker as well before while deciding the disqualification petitions.
Yes.
So going by this paragraph, the MLAs and the Shinde group and the other MLAs, they are still deemed to be belonging to the group of Shiv Sena, at least for the purpose of the Maharashtra Assembly.
Yeah.
And
they belong to the Shiv Sena.
They are the Shiv Sena, right, sir? Right.
Yeah.
So, and ultimately the Speaker has to decide.
Speaker has to decide whether they have voluntarily given up the membership of the party. And Speaker also has to decide who has the authority to issue whip. So when he examines this issue, number one, he has to find out which party these people belong to. And then he will know that they belong to the Shiv Sena. And which Shiv Sena? There is only one Shiv Sena, which is led by Uddhav Thackeray. Because that is the party headed by him which set them up as candidates. And there is no ambiguity about this. So when he decides that, when he finds that all these members belong to the Shiv Sena, then it is easy for him to find out which authority can issue the whip or which whip is valid. So it is the whip which is issued by the Shiva Sena, which is headed by Uddhav Thackeray, that is valid. And if there is a violation of that whip, then naturally you are liable to be disqualified. This is the way anti-defection law needs to be applied.
So, sir, can we envisage a situation where the speaker and the election commission, at least theoretically, are taking contrary decisions? For example, like in the disqualification petitions, the speaker is deciding that they have not disqualified, they are not attracted disqualification. And on the other hand, the election commission deciding based on the larger organization structure that this group, the one particular group is the larger group, which, however, does not enjoy a majority within the house. So in such an eventuality, whose decision should be prevailing? So you had mentioned that 10th schedule will override other laws.
Yes.
So naturally, the speaker's decision should be prevailing in that scenario, I believe.
No, the speaker, if the speaker decides not to disqualify any of these people, that means if the speaker thinks that they have not violated the whip or they have not voluntarily given up the membership of the party, speaker can take a decision that they are not disqualified. He will not disqualify them. In that case, this party can go to the court. That is it. Election Commission's decision, that is a different kind of issue. Whenever Election Commission decides that issue, now suppose the Election Commission decides that this Eknath Shinde is the Shiv Sena. Is the Shiv Sena. But then, as I said a little earlier, it is actually the 10th schedule that will prevail so far as these matters are concerned. Election Commission, let us understand what the Election Commission's powers are in this regard. What exactly is the nature of the power which Election Commission enjoys? It is only for allotment of symbol, not for any other purpose. So it is made very clear in the symbol order. It is only for that purpose, allotment of symbol and reservation of symbol, that the Election Commission will, recognize these parties and decide which party is the real party and so on and so on. But the anti-defection law deals with another aspect, that is the defection from the original party. So naturally there will be conflicts. That is inevitable, but that is why I said in the beginning itself that if there is a conflict, then naturally it is the anti-defection law, that is the 10th schedule, that will prevail because it is the constitutional law. And that needs to be decided. Whatever decision the Election Commission may take, but this needs to be decided by the speaker on the basis of the law, either on the ground that these people have voluntarily given up the membership of the party, or they have violated the whip. Now, both grounds are available to the Shiva Sena led by Uddhav Thackeray to go against them, because all of them have voted against the direction issued by them.
So, in the previous interview, you had criticized the interim orders passed by the Supreme Court to keep in abeyance the speaker's disqualification proceedings. And subsequently later this week also the Supreme Court has said that both the disqualification proceedings, speaker should not decide on any of the disqualification proceedings. So, but now all these issues are now before the Supreme Court as well. Both the sides have questioned the appointment of whip by the other party, the election of speaker, even the floor test. All these issues have now come before the Supreme Court. So how do you think, sir, now what could be a possible court verdict, or how, when we apply 10th schedule to the scenario, how can the situations play out?
No, Supreme Court will have to merely look at the 10th schedule, because that is the law which guides you in such situations. Supreme Court, as I said in the beginning, Supreme Court also will have to see which party is authorized to issue whip and which is the party, Shiv Sena. whether Eknath Shinde is Shiv Sena or Uddhav Thackeray is Shiv Sena. Because that question has come before the Supreme Court. Which party can issue whip? That is the question which has come before the Supreme Court, I think.
So there also the explanation to paragraph 2 that might.
Yes. Supreme Court cannot take a decision on any other basis. So this is the sole basis on which this decision or this issue can be settled. So if the Supreme Court says that Mr. Uddhav Thackeray's party is the authorized party, that is the party which can issue the whip, then the other whip will become infructuous and it will become irrelevant, and the speaker cannot take cognizance of that whip. That's it.
So now, sir, do you think, sir, this interpretation is a very technical view of matters, which is not taking into account the real politics outside? Because as per this explanation to paragraph 2, the official party who has nominated, who has set up these candidates, that will be determined, that will be deemed as the political party. But now politics, many things may happen because one side is alleging that there is an ideological deviation by the other side, and we are the real inheritors of the political ideology of the party. That is one argument. And if that is finding a majority or a resonance within the House and within the electorate, so based on this, maybe perhaps a technical view that the person who has set up the party or set up the candidates, that should be deemed as the official party as per the explanation to paragraph 2. So do you think it is in some way restricting the inner democracy or the political workings within a party?
No, but is there any other basis on which it can be decided other than this? After all, anti-defection law is operating in a particular field. It is for a particular purpose, and that is to stabilize the party system and all that. That is the overall object of this anti-defection law. Apart from, strengthening the moral foundation of democracy and so on, but essentially to stabilize the party system. Now, when you look at that object, then you cannot encourage people moving out of a party out of greed for power and so on. Whatever be the justification, but it is essentially because of the greed for power, actuated by the greed for power. Now, this group, the legislative group, they entered into an alliance with another party without taking into confidence the party leadership. So that is how the party system is being wrecked. Here, the party leadership is not aware of what the legislative wing is doing. In a democracy, particularly in the context of India, how can party system survive if people who are elected by the people on the basis of the popularity of that party? After all, people elect a candidate because he belongs to a particular party which is supported by the people. So basically, it is the party, which is very important, and party is the most important player in our democratic system. Therefore, you cannot be swayed by the fact that ideological considerations, etc., which, according to me, do not mean much, because I have seen politics for a very long time, and I spent 40 years of my career in Parliament, where I was rubbing shoulders with politicians only. Therefore, I have seen the undercurrents of politics, very keenly observed things. So I can say that the ideology is the least factor, which operates in politics. Nobody bothers about that. I don't think any political party gives undue importance to ideology. That is only for public consumption. But here, basically, It is lust for power which propels people towards the power center. That's what happens. And therefore, if you take that as a standard behavior, then of course, there can be other way of dealing with it. But otherwise, if you look at the basic object of this constitutional law which was enacted by Parliament, then you have to go by this law, not by other considerations. Other considerations may come later when a party officially splits and they separate, they go their ways, different ways, and they address the people and the people support them and all that. That would be a different kind of situation. But at the moment, we are grappling with a difficult legal legal and political problem. And here is a law which gives you a certain idea about how to deal with it. It shows the way.
Right. And sir, do you think this is an unprecedented case, because we have some Supreme Court judgments, etc., but these all those were dealing with cases of a clean split, or there was a clean majority there on either side. But a situation like this, where the legislative majority is with one side and the organizational majority is with other side, do you think it's an unprecedented kind of a situation?
Yes, I think it is an unprecedented situation. In all the splits which have taken place in the past, this kind of a situation was not there. There was a split down the middle almost. Organizational wing was there, and the legislative wing on both sides. That is the thing. For example, when the Congress party split, the ACC delegates, because that was taken into account by the Election Commission as well as the Supreme Court. There are 700 kind of delegates were there, out of whom around 350 or more than, little, one faction, the Indira Gandhi's faction, had a kind of a majority, a slender majority. It was there. So that is how they finally decided. Of course, they looked at the party structure and the delegates, the ACC delegates and all that. Then the Assembly and Parliament. All these were taken into account. That means the organizational position and also the support in the legislative wing. So both the things were taken into account to decide which faction is the real party. That is. So you cannot just can't ignore the organizational part of it and say, and the legislative wing can say that, look, we are the majority, so we are the party. That is neither here nor there.
Okay. So, sir, just to summarize the points articulated by you. So the mere majority in the legislative wing, that is not the sole determining factor for determining who is the real political party. The entire organizational structure of the party has to be taken into account. And even in determination of which faction belongs to the real political party, 10th schedule of the Constitution plays a crucial role. And explanation 2 to paragraph 2 of 10th schedule, that says that a member is deemed to be belonging to the party which set him up as a candidate. So a member, so long as he is continuing in the House, he is deemed to be the party which set him up as a candidate in the election. So that explanation plays a very crucial role in determining to which party that member belongs to. And if that member is deviating from that official stand, and if there is no merger as per paragraph 4, then he'll incur the risk of disqualification, which the speaker has to decide. And the essential jurisdiction of Election Commission is to decide to which group the official party symbol should be allocated. But that is again guided by 10th schedule, and that will be subject to 10th schedule. And the decision of the 10th schedule will be overriding the Election Commission's orders and other rules and regulations, being a constitutional law. So, do you wish to add?
Just one more small point. These people had an option, and the 10th schedule had given them an option. That is, you merge with another party, then you will no longer be under the influence of this explanation.
Mhm.
That is it. You merge with another party, then you will be known by that party or by that party's name. That is the thing. So anti-defection law, it's not that it's kind of a cul-de-sac or something. Anti-defection law gives you an opening. If you have the sufficient number, you have the sufficient number.
You have to merge.
And then, of course, the original party has to merge, but because of the High Court's decision, that can be ignored for the time being.
You mean you are referring to the Bombay High Court's decision, right?
Yes, yes, yes.
Which said that even the 2/3 of the legislative party merges. That will
if legislators merge, that is enough. The original party doesn't have to merge. That was the decision. It was a wrong decision, but then it is the High Court decision. That is the law which is applicable in that region. Therefore, the majority of the members move out and merge with another party. So then there is no problem. They can. But here the problem is they want to claim that they are the real party. You know, in English, we say that have the cake and eat it too. So that kind of a situation is there, which may not be possible in all times. I mean, in all situations.
Okay, sir. Thank you so much for explaining this very complicated legal muddle. Thank you for spending your time with us. Thank you so much.
Thank you. Thank you.